would
It's
it be?
unworkable.
Then we have to then see whether it is federal Sharia court, in fact, which can give that sort of declaration. I mean, if it is a civil declaration, for example,
अभी फेडरल शेयर कोर्ट में ये क्वेश्चन गया है आपके इंफॉर्मेशन के मुताबिक?
नहीं जी, नहीं. So if I may, if the dispute is inter se two parties, it's a private civil dispute, and a dispute is decided by deciding a dispute, a finding comes out. I don't know how conceivable would it be, but let's say for the sake of argument, a finding comes out that a person dishonestly not honor its contract. And that finding
to ये डिसाइड ही नहीं हुआ इस जजमेंट के अंदर.
जी सर नहीं,
मेजॉरिटी में भी नहीं, ये भी नहीं कहा किसी और केस में देखेंगे.
ये तो कहा कि किसी और में देखेंगे, ये जो ABCD था, बट जैसे जवाद ख्वाजा ऑब्जर्व दैट इन अप्रोप्रिएट केस वील एग्जामिन इट, बट देन इट वाज नेवर एग्जामिन्ड.
अब देखिए D जो है टॉक्स अबाउट इस्लामिक इंजंक्शंस, E टॉक्स अबाउट इस्लामिक टीचिंग्स, इस्लाम. F though does not mention Islam but kind of brings in the concepts which are recognized in Islam. Now, would this not then be in the domain of the Federal Sharia Court? No court has ever even considered Federal Sharia Court to be competent in this regard.
Could be, my lord.
I don't know.
That is something.
I'm just posing a question.
Gee, I mean, but when we look at a little bit of, if I may take you through.
अब उनकी jurisdiction Federal Sharia Court की on hudud and Islamic injunctions पे.
My lord, there is another aspect.
So I don't know. I mean, it's a very.
इसका एक थोड़ा और एस्पेक्ट भी होगा. वो एस्पेक्ट ये हो सकता है, फॉर एग्जाम्पल अंडर पीनल कोड सेक्शन 403, a person who dishonestly misappropriates property. Now there is an element of dishonesty while misappropriating property, and it's an offense, punishment of which is up to 2 years.
Which some other person has mentioned earlier, then you will be convicted, plus you will be disqualified for life because you're dishonest.
Right, and if the punishment was more than 2 years, so फिर 63(1)(h में आ जाते हैं कि ये moral turpitude हो गया, तो बस वो 2 साल.
I wanted to ask कि moral turpitude में कौन-कौन से offences आते हैं?
Your ladyship, now this term was examined in Samula Baloch, and if I may draw your attention to paragraph 26 of Samula, they actually, after examining various definitions and meanings, Samula then holds that page 432 of PLD 2018, Supreme Court 405, page 438. So moral turpitude's non-exhaustive definition was, so to speak, was provided in Samula.
No, but considering that Ishaq Hakwani leaves the question open, but then Samula does refer to civil original jurisdiction, and they've tried to do that. So they've carved out one, but there too a declaration can't come to this effect, but they've said as a consequence we'll be building that. So is your argument that this is yet not sorted, that unless a procedure is put in place or some sort of...
So
we don't know how to really get this declaration.
Three things actually, all four of them. So let's say a court can be, now Samula says it's a court of civil jurisdiction.
Right.
To my mind, it could be a court of criminal jurisdiction as well.
Right.
As I gave an example, cheating, for example, under Penal Code Section 415 is an offense. Section 417 says that punishment is up to 1 year. Now, up to 1 year doesn't get covered under 63(1)(h. But if a person is
criminal breach of
trust है, उसकी punishment ज़्यादा हो जाती है, वो शायद 63(1)(h) में गिर जाएगा. But anything which is less than 2 years obviously doesn't get covered under 63(1)(h), but can very well fall under 62(1)(f) for that. For sake of what court could it be? It could be any court.
So what are you submitting? You're saying that whatever Samula has come up with, that is also not correct.
That's not correct.
And unless some procedure is laid down by perhaps the legislature as to what kind of declaratory orders could or declaration could come out, which would meet the requirement of 62, till then there is no declaration.
My lord, yes. My lord, a question was raised about 62 and 63 and their interface, and in Sabir Shah's case, 95 Supreme Court, 97. The Supreme Court says that 62 applies at pre-election stage and 63 applies at both pre and post-election stage.
citation है साबिर शाह
Sir, Sabir Shah is 95 Supreme Court, page 66. And the relevant page is
Repeat the citation.
PLD 1995 Supreme Court 66. And the relevant page is 274. Sideline YYY. In this paragraph number 12, just, I need not read it, but it just goes on to say that the qualifications as well as disqualifications specified in Article 62 pertain to pre-elections period. What it does say is that 62 contains both qualifications and disqualifications. Because, and 63 obviously is entirely disqualifications, and 62, which originally was a qualification clause, and because of the violence done to the Constitution through revival of Constitution Order of 1985, D, E, F, G were inserted. Now, because of that insertion, it became a sort of a hodgepodge of both. It became qualifications and disqualifications both, and clause 2 of 62 reflects as much. Now,
this was my question. And in any other judgment, this has been overruled or...
No, sir, this is a 12-member bench judgment, and this is by 7-5 majority, so it's a 12-member bench judgment, never overruled. But then it does acknowledge that 62 contains both qualifications and disqualifications. A, B, C are qualifications, and then the other four...
As per this pronouncement, Article 62 is only applicable
pre-election stage, but so my submission here is that 62, because it contains both, it does apply to pre-election stage. At every pre-election stage, whenever a nomination paper is to be challenged or an election is to be challenged, both theoretically would kick in. My Lord, if I may take a pause here. My Lord the Chief Justice.
Can we come back to Khakwani?
Ji, sir.
Khakwani is a 7-member bench.
That's right, sir.
Samiullah Baluch is a 5-member bench.
That's right, sir.
So the 7-member bench judgment is not worth the paper it's written on. Either we respect the judgments of the Supreme Court or we don't. Now here it says, number of hearings propose the determination of the following constitutional questions by a larger bench. It is a 7-member bench holding. How could a 5-member bench determine this matter then?
It was to be determined by a 7-member bench.
Isn't this binding on the 5-member bench? Is it not binding on the 5-member bench to answer A, B, C, D?
The 5-member bench...
Or it could be argued, that's another proposition, there are these questions which are incapable of an answer. I cannot answer these questions. Like Justice Asif Said Khosa has held. It's not a dissent. That's important. It's an additional note. So how can you just disregard one 7-member bench judgment, either attend to it head on? You can't just say, I ignore these 4 questions. I will decide it myself. You have to say something on Khakwani. You have to say these questions, you want to reframe, these are not properly framed, I don't know, whatever way. But how is a 7-member bench being disregarded by a 5-member bench which has specifically noticed these things? One learned judge had given a very categorical finding on it and have no discussion in the 5-member bench. So why should we not follow the 7-member bench as opposed to the 5-member bench?
That's
why is nobody insisting on Khakwani?
That's why, my Lord, my submission is that Khakwani, without addressing these, without actually acknowledging the existence or presence of this judgment, goes on to hold that it would be a court of civil jurisdiction, without addressing this question that why civil, why not? And in fact, Khakwani says declaration of conviction. So Khakwani perhaps implies that it could be both instances. It could be a civil declaration, it could be a conviction also, which would both be covered under 2 and F.
It just raises questions valid questions.
Yes.
One judge gives an opinion.
That's right.
He said these cannot be decided.
जी बिल्कुल justiciable नहीं है.
No, but at least Samiullah does this, that it addresses the question as to what declaration it would be, and they said it's a declaration coming out of civil.
No. So that again, the Samiullah overlooks that the 7-member bench actually contemplated perhaps both. The 7-member bench said also
But
part
to one
of it.
extent, I mean, to civil only, they've come up with
Part
some
of
answer.
a part of A that they say that जो जहाँ पे कोर्ट का बताना था तो उन्होंने कहा कि civil होगा. It did not then hold that why not a conviction.
And उसमें भी problem ये है, फिर तो अगर if we are, so then we stuck on the very basic question कि declaration from a court of competent law क्या है?
That's right, sir.
So
That has to be answered.
So that's not answered.
Yes.
So बाकी सारी चीजें तो दूर की बात है ना कि duration क्या
Everything
है?
is based on that premise that there is a declaration by a court of law and we don't know.
So we're assuming on Samiullah's argument that there is a declaration which would be between inter-parties arising out of civil jurisdiction, and then as a consequence we'll build into it that the person is not honest.
What would be the effect of that declaration
And in effect we say
the
he's not
consequence
honest.
and so
But
on, and then we come.
I will go another way. I will say I cannot bring myself to disagree with Justice Khosa.
Those were very profound.
What we have read, can I not say that? I cannot bring myself to disagree with Justice Khosa.
Court, my lord, yes.
He's a 7-member bench member. The others have not disagreed with him. They should have said, we don't agree, this is a dissent you're writing. You're not writing an opinion of the court.
So where does that leave us, Samir?
So, my lord, now I think as a first step, in my respectful submission, and as a first step, my lord would have to first have to hold what court would it be or what courts would it be, civil or criminal, either or both, which would give this sort of declaration for the purpose of 62(1)(f)(1). What would be the procedure which will have to be adopted for the purpose of that declaration? What is the standard of proof which would be required, both, and then the locus standi?
In Khakwani, the High Court refused to interfere. The High Court refused to interfere.
Actually, this is a rhetorical question.
The High Court cannot go into such.
सुप्रीम कोर्ट में आर्टिकल 62(1)(f) की पर अटॉर्नी जनरल दलाइल दे रहे हैं। उनकी जानिब से कहा गया है कि समीउल्लाह बलोच केस जो है उसमें इसहाक खाकवानी केस को डिस्कस नहीं किया गया। मजीद अटॉर्नी जनरल ने अहम दलाइल दिए और इस मौका पर चीफ जस्टिस की जानिब से भी रिमार्क्स दिए गए हैं।
लग रही है उसमें मुझे कोई आई एम ट्राइंग टू इन माय माइंड ट्राइंग टू disagree with it, and I can't bring myself to disagree with it. He's saying you cannot give these declarations full stop. So maybe these are just rhetorical questions. They don't have an answer. I mean, there are many questions you don't have an answer for.
इसका एक background, इसकी एक interesting.
However, nonetheless, Parliament has understood better than us and something. Okay, fine, good for you, Parliament. They represent the people of Pakistan. They've understood it, they've done it. Now, unless I can then say Parliament has done something wrong, the only thing Parliament says कि भाई आपके 7-member bench का भी follow करते हुए it is more in tune with the 7-member bench judgment. Section 2, is
Right, sir. मैं थोड़ा सा background बताऊं. My lord was originally explained what the 13 provisions being ABC था 62 में, and the constitution was being made, certain amendments were proposed. And members who belong to religious parties, I'm talking about the original constitution making, at the time of original constitution making. I just read out very slowly, I don't have a copy of it. 2 amendments were proposed and motions were made and they were negative, they were rejected. And I may read out, they are quite akin to what was then inserted through revival of Constitution Order 1985 by General.
where are you reading from parliamentary debate?
Parliamentary debates.
Copies दे दीजिएगा मैं.
जी copies दे दूंगा. I'll just slowly read it out. And these were rejected.
What year is this?
This is, my lord, 1973. These are dated 15th of March 1973, sir. So the first amendment which was proposed, was he is conversant with the affairs of the country, which is okay. He is conversant with the affairs of the country and is not reputed for his bad character or for contravening the injunctions of Islam. This was rejected by the House. Second, if a Muslim, he is honest, and not an open violator of the dogmas of Islam and possesses the necessary knowledge of his religion. Both were rejected. And while rejecting it, the speaker said, and I would just quickly read out one paragraph from the proponent of one of these amendments and the response given by the speaker.
Who proposed these?
My lord, these were proposed by Maulana Abdul Haq of Koda Khatak, Maulana Ghulam Ghaus Hazarvi, and Maulana Mustafa Al-Azhari. So these were the three members who proposed them, and the House rejected them. I just read out, these are very telling passages, what he had in mind, and then how the speaker responded. And this is exactly what Justice Khosa has observed. जनाबे वाला मैंने तरमीम पेश की है कि पार्लियामेंट का जो रुकन हो उसका किरदार, उसका इखलाक, उसका तकवा, उसकी दयानतदारी, इसका मामला शनास होना, इस्लाम के बारे में उसकी बुरी शोहरत ना हो, ये खसूसियात भी लगाई जाएं। असल में इस दफ़ा में ज़ेली तौर से बहुत सी चीज़ें लगाई हैं कि अरकान में इनका होना ज़रूरी है। एहलियत होगी तो मैं अर्ज़ करूं कि ये जो है, यानी जो पार्लियामेंट है, पार्लियामेंट जो है वो तमाम मुल्क में बहुत ही अहम इदारा है। इस ऐवान के अरकान हैं, ये आइन बनाने वाले हैं, कानून बनाने वाले और मुल्क के अंदर अदल व इंसाफ कायम करने वाले इदारे के अरकान हैं। इसका जवाब सर, Speaker responded, and then obviously it was then later put to vote. He said, आप मुझे इसका जवाब दें कि आपने फतवा दे दिया कि इसकी शोहरत अच्छी है और वो अहल है। दूसरे कई उलमाए कराम ये फतवा देते हैं कि इसकी शोहरत अच्छी नहीं है, इसलिए ये चीज़ इसके मुंतखब करने वाले जो लोग हैं, जो वोटर हैं, उन पर छोड़ी जाती है। अगर वो समझें कि वो अहल है तो वो अहल हो सकता है। And then ultimately it was put to vote and it was rejected. So
maybe it's a guideline for the voter.
Yes.
Maybe why can't it be considered a guideline for the voter? Maybe you want, it's maybe not on your radar, but you should consider these points.
Some sort of inspirational standards for future.
D, E, G, and precisely are that. Now, what happened here? Mr. Uzair Bhandari argued, and he relied on paragraph 33 of Samiullah, where Samiullah Baloch, with respect, erroneously relies on Imtiaz Lali case of 2007 to say that pre-18th Amendment, the Supreme Court had disqualified someone for life under 62(1)(f) erroneously. Paragraph 33 refers to Imtiaz Lali, which is PLD 2007, Supreme Court 369, which was incorrect. In Imtiaz Lali case, he was disqualified on the basis of a provision which was introduced in Representations of the People's Act through Conduct of General Elections Order, which was Chief Executive's Order number 7 of 2002, on the basis that a person who was dismissed from service on the basis of misconduct or moral turpitude, full stop. They applied this provision to hold that if he could not get back into service, he could not get back into the parliament either under 63. So this is what Imtiaz Lali did. Now, what did parliament do to respond? In 2010, Parliament then placed timelines for G, H, I, J. Now, J deals with removal from service on the basis of misconduct. They said that if he's removed on the basis of misconduct, he could come back in after 3 years. And on moral turpitude, if he's convicted and after serving the term, he can come back after 5 years. So Parliament had this judgment in mind and responded to it. What Parliament did not have in mind was that while they were creating actually a safety valve under 62(1)(f), against any arbitrary decision by a returning officer, where the returning officer would ask someone XYZ, or somebody would come make an allegation against somebody that he is dishonest or he owed me something and he has cheated me, etc. Parliament pegged it with a declaration by court of law. And that declaration, now as I go in greater detail what that declaration would be, this is the safety valve which the Parliament had created, and unfortunately, from Ghafoor Lady to first Aladino Bhaio, the original Aladino Bhaio, to Samiullah Baloch, this court then actually turned into something which constitution makers never contemplated. Nowhere in 62 or 63 has anything been made perpetual perpetual disqualification.
No, but before we even get to the time frame, what I'm understanding from you is that we haven't yet crossed the first hurdle as to what kind of a declaration this is. Because under the current dispensation or legal framework, no such declaration can come about. Samiullah goes ahead and crafts a declaration, says that in case there is some civil litigation which comes up with something, then we'll, as a consequence and as an effect, connect it and make him dishonest or a mean. So there is no direct mechanism or procedure available in the current legal framework to achieve such a declaration. So having said that, one option could be that the parliament goes ahead and decides the procedure, or there is a constitutional amendment, whatever might be the case. How could a court of law like us resolve this issue? Because under the current legal framework, such a declaration cannot be given. So what happens if there's a constitutional provision which becomes practically unworkable under the legal system? What do we do with that provision?
My Lord, my respectful submission is, and I attend to my Lord's question, but if I may just first submit, that such declaration, now if we look at the courts of civil jurisdiction and see a declaration is given by a civil court, this sort of becomes a bit inconceivable, because in what situation would that declaration come out? But if this declaration in the form of a conviction is given by a criminal court, then there are several instances where such conviction regarding the character, which is the honesty or dishonesty of a person, could be given by criminal courts and penal court. I just gave an example of section 403 of penal code. A person who dishonestly misappropriates somebody's property, upon conviction he is punished. Punishment is up to 2 years. The 3.1H is threshold doesn't get triggered because that is more than 2 years. So remaining under 3 years, under 2 years, there is a declaration of having dishonestly misappropriating
It's not a
property.
civil declaration that's the problem.
Civil declaration is a problem. Now, similarly, cheating, for example, is being deceitful, which is dishonesty.
Sure.
So again, it's 1 year. So वहाँ पे शायद आ सकता है, वहाँ पे शायद आ सकता है. Civil declaration, as my Lord has just observed, I can't think of any.
So then what is the answer?
Now, my
It
Lord,
is the first question that since Ishaq Haqqani is pending, right?
Ji.
So unless we cross this hurdle, building a time frame and all that is a secondary question.
so that is one. That is one. That it is all.
So it is best either you leave it to the parliament to do a constitutional amendment or do whatever they want to come up with.
For that, you don't need the
Besides this.
constitutional amendment. Now, this is my second submission.
नहीं, मुझे एक चीज बताएं, ये हम फंस गए समीउल्लाह बलोच में. अगर जब ये खाकवानी का आपने जिक्र किया, मैंने अभी पूरा जजमेंट देख रहा हूँ समीउल्लाह बलोच का. ये कोई बहुत पुराना जजमेंट तो नहीं है, नेचुरली रेडार पे होगा. दुनिया भर के वकील इसमें पेश हुए, एक ने जिक्र नहीं किया खाकवानी का. I find that very difficult. और उसमें जो सवाल उठाए गए थे, तो मतलब उसको नजरअंदाज कर दें, हम दूसरी तरफ चलते हैं. मतलब मुझे कुछ गैर मुनासिब लग रहा है.
These questions had to be addressed.
एड्रेस नहीं, कोई पुराना कोई नहीं, कोई 10 रिपोर्टेड जजमेंट है, PLD में लिखा हुआ है उसको. तो वो पूरे जजमेंट उसका तस्करा ही नहीं, और हम फंसे हुए समीउल्लाह बलोच में. हम खाकवानी पे क्यों ना जाएं?
बिल्कुल जाना पड़ेगा, जाना पड़ेगा, जरूरी है.
नहीं, मतलब अगर नहीं, आप देखिए, जो चीज हमें समझ आती है. अब सपोज एक मैं नया टर्म इस्तेमाल कर देता हूँ, मैं कल को आइन बदल देता हूँ, उसमें लिख देता हूँ पार्लियामेंटेरियंस मस्ट बी इंटेलिजेंट. ठीक है, फेयर इनफ. कौन डिटरमिन करेगा? कोर्ट ऑफ लॉ करेगी? कर ही नहीं सकती है. मैं ये आपको कह रहा हूँ, मेरे हिसाब से ये कोई चीज भी कोई कोर्ट नहीं डिटरमिन कर सकती, क्योंकि उनके जुम्मे आता ही नहीं है. कोर्ट डील विद नॉट philosophical concepts, court deal with tangible things. How can you determine someone's honesty? And it's a variable. A person may be honest today, dishonest tomorrow, honest today, dishonest tomorrow. I don't know, people keep changing. So these are not the kind of determinative things. Probably the 18th Amendment brought in the word through a court of law to virtually kill it off, but they didn't realize they probably created more of a mess than the original wording. I don't know, that maybe have been the intent. अब पार्लियामेंट ने काम कर लिया है, मुझे नहीं समझ आया. अगर उन्हें कर लिया है, चलें, गुड लक टू देम. उन्हें का 5 साल, फाइन. Why can't we live with it? I mean, जब 7 मेंबर जजेस कह रहे हैं कि ये सवाल है, या तो उनको अटेंड करें, आप इग्नोर नहीं कर सकते हैं कि जी आप मैं दूसरा जजमेंट लिख दूं मैं उसको इग्नोर कर लूं, जब बिल्कुल वही चीजें हैं, वही इशू है, वही इलेक्शंस की बातें आ रही हैं और आप उस तरफ चल पड़े. सॉरी, मेरे हिसाब से आई एम रीडिंग मोर एंड मोर ऑफ जस्टिस कोसा's जजमेंट एंड आई फाइंड दैट द आंसर यू कैन नॉट answer these questions. Not every question is answered. Some are answered in the hereafter. Some are answered, okay, if I take a vote today, no disrespect to you, is Mansoor Rahman an intelligent person? Maybe some will say no, most will say yes, I can assume. So these are opinions. I mean, you may hold a thing on myself, they'll have an opinion on me. But it's not something that I can get a declaration from a court of law. Declaration of court of law means that you cannot have a second opinion on the matter. End. Khatam.
No, but having said that, the legislation that's come about is also ignored Ishaq Hakwani, because where is the answer to what kind of a declaration should it be? It just answers the time frame. That's a secondary question. The legislation should have thought that there's a Ishaq Hakwani raising all these questions. They should have explained where do we get such a declaration? How do we do it? What's the procedure as it mentions? But all these things are missing. So, I mean, we can't even get to the second question if we want to take it head on, unless we can come up with some sort of a sandwich definition of a
जवाब में मैं ये कह सकता हूँ कल शायद पार्लियामान करने दें उनको अपना काम.
Fair enough. So I'm just saying that even if we were not to address this head on and come up with some sort of a sandwiched answer to a declaratory order or whatever declaration, it will lead to problems for the future again.
Now, at the end of the day, we have to establish one thing once and for all. You believe not just in election. कराना ही तो एक प्रोसेस है, प्रोसेस से तो आपको कुछ मिलता नहीं है. Democracy means that the will of the people is reflected. The will of the people, whether they bring a constitutional amendment, whether they bring a legislative thing, it is the will of the people, whichever way you look at it. The next lot of parliamentarians will come, they will make a law saying this will be a lifetime ban, then we can consider its constitutionality. Our role should only be not to fill in the constitutional gaps if there are any. Our role should only be to examine legislation. Does it accord with the Constitution? And I would go back, I may not even agree with Parliament, but I will keep quiet about it. As a voter, I may do something else. So why are we getting bogged down in this business? Why are we doing this job?
So if I may just address both these questions, observations and questions. The declaration under 62(1)(f) has to be by a court of law, acting under a law.
सुप्रीम कोर्ट में आर्टिकल 62(1)(f) की तशरीह के केस की समाअत जारी है, जो कि براہ راست नशर की जा रही है. इस मौका पर अटॉर्नी जनरल ने दलाइल देते हुए कहा कि समीउल्लाह बलोच केस में किस मुतल्लिक बात की जाए.
Procedure, manner and duration of qualifications and disqualifications will be such as is provided under 62 and 63, and where there is no procedure, manner provided, it will be such as is
provided. The legislature is actually not addressing that.
Now this declaration question has been left open.
It is not the answer of
not been addressed.
It's not addressing the question.
It is not. Now what it does is, it says that whenever that declaration comes out, the effect of that declaration would be for 5 years.
That's it.
That's the only thing it does.
How that will come out?
Yes.
So I wish the wording was that the declaration.
I appreciate
that, but that's a separate issue.
Read out,
But I think that's a secondary issue. The main issue is, what do we do? I mean, we can't even say that this legislation has come up with an answer either.
So
Declaration subject to due process of law, ये लिखा हुआ है.
due process of law, and then it says that the disqualification shall not exceed 5 years from the date of declaration.
I'll tell you what Parliament did.
Parliament has.
उन्होंने कहा हम इसको बस छोड़ो, इस बहस में पढ़ो नहीं, 5 साल कर दो, खत्म. that's in a nutshell what Parliament did. We can't tell Parliament to craft a law this way because in my mind, this is the best way to proceed. This is their job. Our job is another job. Is it unconstitutional?
My lord.
One proposition was put forward, do not touch upon 232. You may need to touch upon 232 at another juncture. I'm just speaking aloud for myself, I tend to agree with that. Nobody has challenged it. We assume it's okay. Till someone comes and attacks it, maybe it's a very good attack. I don't know. Maybe they say, "Ki 5 saal bhi kyun?" I don't know. Let's leave all these things. The fact is someone has applied their mind and made a law. And that law specifically mentions all judgments of any courts. So that law has shown us respect in the sense that they have just, like my Honorable Justice Afridi has said, it was not lifetime thing. So they've kind of brought it about by this legislation 5 years over. अब ये बहस किसी और दिन के लिए रखेंगे हम, अगर जरूरत पड़ेगी या नहीं.
And then also this important question.
What do we say about declaration?
Now, it seems that at the time of Samiullah, the court was pushed to do the work of the parliament. And now again it is being presumed that we will do the work of the parliament.
And court has not said for the permanent disqualification, it is only as long as the declaration will remain in field. Again, I will put you this question, why the section 232 cannot fix the period of that declaration?
It can, sir. Because, and I respond
And
to
there
this.
is no
It can, sir,
inconsistency between the Samiullah and the Act.
Because 62(1)(f) has two components. One is this cause of this disqualification. This cause of this disqualification, and cause of disqualification is a declaration by court of law. So this declaration or this cause is rooted in law, resulting in a declaration by a court of law, and the consequence is constitutional, which is a person stands disqualified. Now what the parliament has done is it has limited and placed a certain limitation upon the cause, the declaration. The consequence stays where it is. Now the
Declaration means the disqualification will remain in field for 5 years.
in this case, 5 years.
Section 232.
Yes. And if, for example, if there was no 232(2) and Samiullah is overturned, then the disqualification would only be for that election. For that particular election, which is declared either void or a person is de-seated based on that declaration. He would become eligible after overturned. But this law is a certain limitation, longevity to that declaration of 5 years, which, my Lord, Parliament in its wisdom thought that if under 63(1)(h) we had provided 5 years at that time, then because this declaration is coming under a law and constitutional amendment is not required, it is only perhaps fair that we give a cooling off period of 5 years.
So what is the procedure to deal disqualification under section 6, under Article 63?
Sir, now when a declaration is come and the question arises, a person has become disqualified, and chairman or the speaker under clause 2, the question goes to them and then they refer to election commission.
Sub-Article 2 and Sub-Article 3 of Article 5.
That's right.
Mr. Ji, Article 62(1)(f) says court of law. The criminal court is not court of law. And why? It's restricted only to civil court.
Or unless my lords are minded to hold, in my respectful submission, it could be a declaration by a civil court or conviction by a criminal court. It may entail these consequences, but that is
It is assumed.
सुप्रीम कोर्ट में आर्टिकल 62(1)(f) की तशरीह के केस की समाअत जारी है, जो कि बराह रास्त नशर की जा रही है। इस मौके पर अटॉर्नी जनरल दलाइल देते हुए कहा कि इसखात ने लिखा कि मामला मुतल्लिका केस में देखेगी।
इसका मतलब है कि despite that declaration, the election commission can undo that declaration.
No, the election commission, for example, disregarded declaration, then a person can come before your lordships or in the High Court under 199 and say that here is a declaration.
Validity of the declaration issued by court of law.
Yes, so declaration is not the validity which can be questioned by the election commission or by the speaker or a chairman in that case. If we come to the conclusion that this declaration is actually not 62(1)(f) declaration, this is perhaps for an offence of something which is not
So,
covered
Mr.
in
Mansoor, you
62(1)(f).
landed us in a bit of a more problem here. So the question was earlier that we were going along whatever semblance of a declaration was given by Samiullah or civil litigation, original civil litigation. We thought we'll take that. Semblance of a declaration was given by Samiullah or civil litigation, original civil litigation. We thought we'll take that declaration and then play around with the duration period. Here the question is that there is no declaration and that's not really a declaration, and Isaac Kwani raises that question. Nobody has addressed it head on as to what could be such a declaration, and that declaration probably requires some serious thought from the parliament. So where does that leave us now?
So, my lord, what that leaves to your leaves you, the declaration so far given, people might come in due course to the courts that these declarations were not declarations by a court of law.
I put myself in the position of whatever that court is for the time being. I would say I cannot give this declaration. Bye. Take away your suit. Take away your plane. Take away whatever you want to do. I cannot do this. I mean, I cannot go into your hearts and determine what sort of human being you are.
That's right.
Only
So taking that question further, what do we do with the constitutional provision now?
So what happened here?
Say it's unworkable, wait till the parliament decides how
My
to
friend,
make it work.
इसका भी जवाब आसान जवाब है, बहुत आसान जवाब है. इसका बहुत आसान जवाब है. जो लोग कॉन्स्टिट्यूशन बनाने के माहिरीन थे, उनमें ज्यादा अकल और दानिश थी. उन्होंने 73 का आइन बना दिया.
और उन्होंने ये
एक साहब टहलते हुए आए, उन्होंने कहा हो कहीं ये लोग सर ना खड़ा कर लें, तो ऐसी चीजें डाल दो इसमें कि हर कोई जो मेरी मर्जी हो मैं उसको डिस्क्वालीफाई कर सकूं. अभी इस बात को हम क्यों नहीं कह रहे हैं, इसको बात का एतराफ क्यों नहीं कर रहे हैं? तो समीउल्लाह बलूच स्पेसिफिकली मेंशंस दैट इट वाज इनकॉर्पोरेटेड बाय इन द ड्यूरिंग मिलिट्री टेकओवर.
बिल्कुल.
So I mean,
The revival of
I don't know why we so
1985, but 18th
we go
Amendment
into
में Parliament had
niceties
the
of grammar and English and we are forgetting the overall picture.
18th Amendment. The problem is that
18th Amendment भी वही मसला है ना कि इधर आपने देख लिया क्या हालत हुई थी पाकिस्तान में, वो भी हम क्यों नहीं बात कर रहे हैं उस बात की. जरा सी उन्होंने लैंग्वेज बदल दी तो उन्होंने पता नहीं पूरा पाकिस्तान came to stand still. We must realize that there are issues which are exploited for personal ulterior motives.
my lord,
Gain certain political advantages.
That's how things-
Now, once we are not a court of law that we should shy, we are not that we should shy away. We are a court of law, upholding the Constitution of Pakistan. Constitution does not, rightly or wrongly, does not provide a time period. Why should I fill in what the Constitution has intentionally left, even if I accept it at par with every other constitutional provision, something brought in by a military dictator? भाई उन्होंने नहीं किया, वो जाने मैं क्यों काम उनका करूं? नहीं आपको जरूरी करना है. क्यों? भाई देखें, absence is also a decision. If I don't decide to do something, I'm deciding something. Parliament has elected to remain, leave it aside. We also leave it aside.
my lord,
अगर वो कल कोई कानून साजी करेंगे हम देख लेंगे उसको.
Mubashir Hassan case mein, my friend Ahmed Qayyum read out paragraph 115 from Mubashir Hassan, where the full court held that 62 is not a self-executory provision. 62(1)(f) is not a self-executory provision.
वो
And they
कितने
were,
judges थे?
sir, it was a full court. It was, I believe, 15 or 17, full court, thi, sir.
What context was that?
So they were looking at examining 62(1)(f) because it was NRO which was under challenge. NRO under challenge था, तो उसको वो देख रहे थे, and उसमें 62 को उन्होंने examine किया, 62(1)(f) को, and they went on to hold that it is not a self-executory provision, and by that I think it doesn't explain it in that detail, but perhaps the rationale behind that was that because there is a declaration by a court of law which is required, then there is a law or several laws must also provide some mechanism how that declaration is to then come out. Now, what has happened here is that 232.2 provides a time frame for the longevity of that declaration, but it does not then address the four questions which were left open by.
I mean, this constitutional silence has really got us.
नहीं sir, अब आप उसका ये कर सकते हैं. Options here. Either you leave it to the parliament.
Yeah.
Elections are around the corner. Leave it to the
Till
parliament.
then, what is the status of this provision?
So this provision is, as the Supreme Court held, is not a self-executory provision. It requires making a law. The law has to be made, and that is for the parliament to do.
नहीं, अगर ये इन्होंने वर्डिंग लिखी है स्पेसिफिकली, मैं मुबशर हसन देख रहा हूँ. मुबशर हसन में जरा गिनते हैं 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 17
पैराग्राफ 115.
हाँ, 115 में 17 जजेस हैं, यानी कि फुल कोर्ट. It is true that अच्छा the provisions of Article 62 of the Constitution cannot be pressed into service because it is a provision of Constitution which is not self-executory. तो ये तो फिर बुनियाद ही उड़ा देता है बाकी जजमेंट्स की. इससे अगर मैं डिसएग्री करना चाहूँ, मैं कर ही नहीं सकता हूँ, क्योंकि अगर हम सारे जजेस भी बैठ जाएं फिर भी हम 17 नहीं बनेंगे.
Did Ishaq Hakwani look at this?
Ishaq Hakwani did not, I think.
तो Ishaq Hakwani probably realized
Ishaq Hakwani was perhaps
अच्छे सवाल हैं मगर इनका जवाब नहीं मिल सकता.
But Ishaq Hakwani would have, if it had gone on to examine it, I think this question would have come forth that because this provision actually requires making of a law by the parliament to give effect to this.
There is a reference to a judgment, Muhammad Afzal versus...
This is Raja Muhammad Afzal versus Muhammad Altaf Hussain, sir.
तो फिर
1986, 1736, it said that...
Finding तो आती
That judgment said that it's a declaration.
आइन के आर्टिकल 62(1)(f) की तशरीह से मुतल्लिक केस की समाअत दौरान अटॉर्नी जनरल मंसूर उस्मान ने अपने दलाइल में कहा कि 2015 के इसाक ख्वाकवानी केस का हवाला देते हुए समीउल्लाह बलोच केस में इसाक ख्वाकवानी केस को डिस्कस नहीं किया गया. चीफ जस्टिस ने कहा कि आखिर हम इसाक ख्वाकवानी के केस को क्यों नहीं देख रहे, समीउल्लाह बलोच में ही क्यों फंस गए हैं.
Electorate.
Yeah, then they
F also is an appeal to the
after
electorate.
this finding, they just join the family of the rest. You see, D, E, and G. They all become nice, inspirational guidelines that we must have a parliament like this. And that's it.
That's it. And if we have an appropriate law providing for how that declaration would have to come forth, it is.
अटॉर्नी जनरल ने बताया कि समीउल्लाह बलोच केस में खाकवानी केस को डिस्कस नहीं किया गया. जस्टिस शवातिस ख्वाजा ने लिखा था ये मामला मुतल्लिका केस में देखेंगे, इसके बाद ये मामला कभी नहीं देखा गया. जस्टिस काजी फैज ईसा ने कहा कि किसी ने ये नहीं कहा कि ये मामला फेडरल शरीयत कोर्ट के इख्तियार में है.
Not provide for the procedure and manner.
In Samiullah Baloch, Mubashir Hassan was mentioned or no?
No, I don't imagine, sir. I did not come across more.
कि मुबशिर हसन में कहा है कि विच इज नॉट सेल्फ एग्जीक्यूटरी, ठीक है. बट अब समीउल्लाह में अगर हम देखते हैं, समीउल्लाह में उन्होंने कहा कि सिविल कोर्ट का जजमेंट होना चाहिए, तो उन्होंने भी सेल्फ एग्जीक्यूटरी तो नहीं कहा है, उन्होंने भी कहा है कि जजमेंट होना चाहिए सिविल कोर्ट का. देयर मस्ट बी सम डिक्लेरेशन बाय द सिविल कोर्ट.
ये उन्होंने कहा, और ये उन्होंने जरूर कहा, और ये अल्ताफ ये उन्होंने जरूर कहा कि जी डिक्लेरेशन होना चाहिए. एंड परहैप्स ये
नहीं, ये पढ़े ना, जरा वापस आइए 114 पे आए, पैराग्राफ पेज 423 ऑफ मुबशिर.
उसकी एक रीडिंग ये हो सकती है.
नहीं, वो पढ़ेगा. इट इज ट्रू, जरा देखें उसमें, तो फिर आगे वो कह रहे हैं पैराग्राफ 114 का लास्ट जो है, इट इज नॉट that self-execution.
It is true that section, it's Article 62(1)(f) of the Constitution cannot be considered self-executory.
Again, is relevant.
But if a person involved in corruption and corrupt practices has been finally adjudged to be so, then on the basis of such final judgment, his candidature on the touchstone of 62(1)(f) of the Constitution can be adjudged to the effect whether he is sagacious, righteous, non-profligate.
So how is it to be judged? तो उन्होंने भी नहीं छोड़ा.
So,
उन्होंने भी लिमिट कर दिया है where a person is involved in corrupt practices.
It actually perhaps goes a step further to say that एक आपके खिलाफ conviction आ गई कि आपने cheating की है 415 की, तो उन्होंने कहा कि उसके बाद जब वो आ जाएगी तो फिर देखेंगे कि आप फिर dishonest थे, फिर भी थे कि नहीं थे. So,
in corruption and corrupt practices तो ये NAP का reference है. NAP का reference.
जी वो तो NAP का था.
Dr. Mubashir's case will not be 14th and 16th of December 2009.
That's right.
Whereas the 18th Amendment
62 declaration by court of law came
वो बाद
later.
में आया. तो इसलिए ये
उस हद तक नहीं,
उस हद तक ये आप उस पे reliance नहीं कर
वो
सकते.
ठीक है सर बात, but what it does say is, it does the part of paragraph.
क्योंकि देखें legislature
जी ठीक है.
ने टाइम नहीं था दिया हुआ.
जी ठीक है.
यहाँ पे
five के ऊपर, where the court holds that if there is some finding of corruption or corrupt practices, because it was examining it in that context, comes out and a person is convicted, then he will again have to be adjudged.
नाअहली केस के वक्फे के ताहयात नाअहल क्यों?
अब जजमेंट भी हो जाए फिर भी वो एडजुडिकेट दोबारा किया.
वो adjudicate, that's what it says. And then 62(1)(f) also perhaps goes on to hold as much.
On a lighter note, if you permit, Attorney General, in the morning on the reference I had quoted Winston Churchill, and probably Winston Churchill can again be quoted on a riddle wrapped in a mystery inside an enigma. So I don't know, maybe that is appropriate. And I just wanted to mention, there may be questions why all the judges are not here during the reference. A judge has had surgery, eye surgery, another is indisposed, 2 out of the country, and 2 on holiday. So everyone else present here was at the reference.
My lord.
So maybe Churchill comes to our rescue.
My lord.
It's a riddle wrapped in a mystery inside an enigma.
My lord, the situation now, you had 2 questions before yourself in the first order, which my lord.
वो तो 3 member bench का था.
पहला ही सवाल सर.
नहीं हम वही ना, मैं आपके सामने तो ये था कि समीउल्लाह बलोच और 232 में से क्या चीज चलनी है. I think no one across the aisle has seriously disputed or has seriously, other than Mr. Bidari perhaps, has defended Samiullah Baloch. Because Samiullah Baloch does not
serious
answer.
problems with it. He also said there are serious deficiencies, or I think that's the word he used.
And in my respectful submission, there are actually very acute, serious problems with it, because it does not provide answers to the questions which go to the very root of what can happen under 62(1).
Because, I mean, we are all relying on Samiullah Baloch, thinking that primarily it decides that once a disqualification takes place, it goes for life.
Yeah.
The more important aspect of it is, where is that declaration first coming from? And what is that declaration which Ishaq Hakwani says, please understand that. So they're not assuming that they've written it. They said that it's coming out of original jurisdiction, civil original jurisdiction. Is that the correct answer? Is something that we need to understand. Because it stops there, then forget about the period.
And also one more aspect, because Samiullah assumes that it would be a civil declaration. It disregards what Ishaq Haqqani had just noted, and it also disregards Justice Ijaz Afzal Khan's majority opinion in Panama 1, 2017 Supreme Court 265, where when he said what would be the court of plenary jurisdiction, he said it could be both civil or courts dealing with
If
both
it's a
civil or
criminal conviction, then it has automatically taken care of in 63, you see, so it has to be civil. Because if there is a conviction, automatically it gets sorted in 63.
No, but 63 then...
You don't have to really think about 62.
No, all convictions are not covered.
Yes, my lord,
all convictions are not covered under...
As for example, I said cheating punishment is 1 year. Now 63 1H doesn't cater to it, but it could be covered under 62 1F. And there could be other instances also, dishonest misappropriation of property.
अहम करने की करार